In this video, we're going to talk about giving assets to your kid. Is it a good idea? What are the pros and cons? Hi everybody, I'm Richard Barid with Smith Barid LLC. I'm an estate planning attorney here and one half of the estate planning guys. So it happens at least a few times a week. People will come in and talk to us and say, hey, I'd like to give all my assets or most of my assets to my kids. I think it'll have tax advantages or Medicaid advantages. Sometimes they come in having already done it, which makes it very hard for us to undo it and do the right thing. So in some cases, there is a good case for giving away your asset to your kids, but it's a last resort. The way we look at it, you've worked hard for those assets. You may have inherited some, you've been disciplined, you put it away, you've preserved it. And yes, it should be there for your kids, but unless you just want to give it to them during your lifetime, you don't have to do that. There are other ways to go about securing the kind of protection that people want to get, or they think they're going to get, when they pass assets to their kids during their lifetime. So the most common thing we hear probably is taxes. I want to use the annual exclusion, which is right now when this video is being taped, it's $17,000 per person per year. So it's possible for a wealthy parent to get rid of, so to speak, that money, get it to their kids so that their estate will be taxed less in the long run. Here's the kicker though, almost all of the people who come and tell me they've done that or they're going to do that, they don't have an estate tax problem. Right now, unless you have $12.92 million, 2023, $12.92 million, or for a married couple, almost $26 million in combined assets, you don't have an estate tax problem. And most people, even those who are doing very well, might have $1 million or $2 or $3 million, a lot of money, but not enough where you ought to be letting the tax tail wag the dog. It's not a good enough reason to make tax planning the centerpiece of your estate planning. There are other ways to do it. So let's think about it. We hear people talk about estate tax. We've talked about that. People think about capital gains tax, and they think by passing assets off to their kids during their lifetime, they might save their kids or themselves some capital gains tax. So for those of you who don't know, which probably isn't too many of you, capital gains tax in a broad sense is if you bought shares of Microsoft at $10 a share back whenever that was, and now it's worth $500 per share, all of the gain, all of the amount of money between the $10 per share you paid and the $500 per share it is when you give it to your kids, that's all capital gain that is taxable. If you wait to pass those assets to your kids through a testamentary document, right, through a living trust or through a will, if that's the triggering event, your passing is the triggering event of getting those assets to your kids, the kids get what's called a stepped up basis. So that means if they needed to turn around and sell those assets, their tax basis is the value of the shares of stock on the day you pass away, or within 6 months of the time that you pass away. You can make an election there. And so the kids could sell that if they needed to sell it with no capital gains tax to worry about because of that stepped up basis. By contrast, if you go ahead and give the assets to your kids during your lifetime, they get what's called a carryover basis, and that means your tax basis, the $10 per share, is now their tax basis. So if they go to sell it, if they need to liquidate or just want to liquidate, they're going to have a huge amount of capital gains, a huge amount of those assets that are subject to capital gains taxes, where we could avoid that by leaving the assets for them when you pass away. And then there's the property tax issue, right? A lot of kids say, I'm going to give away my house to my kids to prevent Medicaid from coming to get it. And that's a common misconception. We'll talk about that. Medicaid doesn't just immediately come and get the house, but people are worried about it, so they transfer their house into the name of their kids. And one of the problems there, there are other problems, but one of the big problems is right now in the home you live in, you probably have what's called a homestead exemption. That means you pay far less in property taxes than you would if that home was not your residence. So then you can see if you give the property to your kids during your lifetime, they'll be owning it, you'll be living in it, assuming that's the plan. If you're going to continue to live in it, then it's not their residence, it's your residence, and they don't get that homestead exemption savings. So it's a better idea in many cases to pass those assets off in a testamentary way, which I'd said earlier. Testamentary just means that the triggering event for passing those assets is your passing away, the owner of the asset passing away. Now, probably the biggest reason I hear people say that they want to give away their assets to their kids during their lifetime is they don't want Medicaid to come and take the house. And that's a common misconception. Medicaid, even if you qualify for it and start taking the benefit, they don't immediately come and take the house. What they do is you have to report when you apply for Medicaid, you have to report that you own the home or some interest in the home. They tuck that information away. They continue to pay the nursing home costs or whatever it is they're paying on a monthly basis. They keep a running tally of what they've paid. And then when you pass away, they'll want to put a lien on the house so they can get as much money as they can to be repaid or reimbursed for the benefits they provided you when you needed them. The point is to get that money back into the flow of Medicaid so that it could be used for someone else who needs that money. But it's an unfortunate result of the need for nursing home care and satisfying that need through Medicaid that we create the potential, at least, for a lien against the home. Now, typically, Medicaid has a policy of not acting on that lien until you and your spouse and any dependent people, so even if they are adults, if they are dependent kids, once all of those people are out of the house or no longer need the house, that's when Medicaid may come to try to foreclose the lien. And that's an unfortunate result, but it's not the end of the world, especially if the trade for that is you get the kind of care you need, paid for in part or maybe in large part by the Medicaid program. So there are problems with moving your house out of your estate or moving assets out of your estate. One of those is that if you move the assets out of your estate during your lifetime, you no longer have control. You're divested of all control, but it's not that way. Medicaid, your house is not subject to a Medicaid lien, but the house is now subject to any concerns your kids might have. So if you transfer your ownership of your home to your kids, what if your kids have debt? They might not have debt now, but maybe there's a bad accident that exceeds the limits of their insurance, or they get into an unfortunate medical situation and they drive up run up these large medical bills, and the medical bills can't be satisfied by whatever payment they're able to make. Well, those debts can come back and attach to what you're thinking of as your home because it's now their home. Same thing can happen with a divorce. If a child owns your home and they get divorced, that house could wind up being marital property, at least in part. Maybe the whole thing is marital property, depending on what state you're living in at the time or they're living in at the time. So now the home you live in is an asset subject to some sort of division in a divorce court. And then, of course, there's a really hard thing to think about, which is what if your kids die before you do and they don't have any planning in place? Now, they could put a will in place that says, if I die before my parents die, the house goes back to them, but most people wouldn't think of doing that. Most attorneys wouldn't think of advising them. But if you don't do that, if they don't do that, and they own your home, they pass away, that house might go to your daughter-in-law, your son-in-law, or even your grandkids or great-grandkids, and they may do the right thing and return ownership to you, or they might not. They don't have to, is the point. You're losing control. Another reason we sometimes see people say, I want to give my assets away to my kids during my lifetime, is they're thinking they want to avoid probate. And probate court is an annoying form of government intrusion. It is a court process. It can wind up being contested. There's good reasons to avoid probate, but there's another mechanism, maybe more mechanisms. The most common mechanism is using a revocable living trust to replace a will. We've got other videos available about revocable living trust, but in very short general explanation, that trust is a container into which you put assets, including your home and whatever assets it is you might be giving away to your kids, and they stay in the trust. You have control, and then when you pass away without probate, the terms of the trust control and would move that house or those assets to the kids, and avoiding probate, but without you having to give up control of your home or your assets that you've taken so long and so lovingly set aside and been disciplined about not spending them. You can keep control of all of that with a revocable living trust and then avoid probate at the time you pass by use of that same trust. Thank you for spending time with me talking about should I put assets in my kid's name. If you'd like to find out more about how we can help your family, please click the button below and it'll help you make an appointment for what we call a discovery call with our team here at Smith Barid to see how we can help you. Thank you.